Narra Nickel Mining and Development Corporation vs. Redmont Consolidated Mines Corporation. GR. Number 195580, April 21, 2014. Facts. Respondent Redmont Consolidated Mines Corp., a domestic corporation, took interest in mining and exploring certain areas of the province of Palawan. After inquiring with the Department of Environment and Natural Resources, DENR, it learned that the areas where it wanted to undertake exploration and mining activities were already covered by Mineral Production Sharing Agreement, MPSA, applications of petitioners Narra, Tesoro and McArthur. Redmont filed before the Panel of Arbitrators, POA, of the DENR 3 separate petitions for the denial of petitioners' applications for MPSA. In the petitions, Redmont alleged that at least 60% of the capital stock of McArthur, Tesoro and Narra are owned and controlled by MBMI Resources, Incorporated. MBMI, a 100% Canadian corporation. Redmont reasoned that since MBMI is a considerable stockholder of petitioners, it was the driving force behind petitioners' filing of the MPSAs over the areas covered by applications, since it knows that it can only participate in mining activities through corporations which are deemed Filipino citizens. Redmont argued that given that petitioners' capital stocks were mostly owned by MBMI, they were likewise disqualified from engaging in mining activities through MPSAs, which are reserved only for Filipino citizens. In their answers, petitioners averred that they were qualified persons under Section 3, AQ, of Republic Act No. RA, 7942 or the Philippine Mining Act of 1995. Additionally, they stated that their nationality as applicants is immaterial because they also applied for Financial or Technical Assistance Agreements, FTAA, denominated as AFTA of BO9 for McArthur, AFTA of BO8 for Tesoro and AFTA of BO7 for Narra, which are granted to foreign IGNA-owned corporations. Nevertheless, they claimed that the issue on nationality should not be raised since McArthur, Tesoro and Narra are in fact Philippine nationals, as 60% of their capital is owned by citizens of the Philippines. They asserted that though MBMI owns 40% of the shares of PLMC, which owns 5,997 shares of Narra, 40% of the shares of MMC, which owns 5,997 shares of McArthur, and 40% of the shares of SLMC, which, in turn, owns 5,997 shares of Tesoro, the shares of MBMI will not make it the owner of at least 60% of the capital stock of each of petitioners. They added that the best tool used in determining the nationality of a corporation is the control test, embodied in Section 3 of RA 7042 or the Foreign Investments Act of 1991. They also claimed that the POA of DENR did not have jurisdiction over the issues in Redmont's petition since they are not enumerated in Section 77 of R.A 7942. Panel of Arbitrators disqualified herein petitioners. The POA considered petitioners as foreign corporations being effectively controlled by MBMI, a 100% Canadian company, and declared their MPSAs null and void. In the same resolution, it gave due course to Redmont's EPAs. Court of Appeals upheld the decision of Panel of Arbitrators. Court of Appeals found that there was doubt as to the nationality of petitioners when it realized that petitioners had a common major investor, MBMI, a corporation composed of 100% Canadians. Pursuant to the first sentence of paragraph 7 of Department of Justice, DOJ, Opinion No. 020, Series of 2005, adopting the 1967 SEC rules which implemented the requirement of the Constitution and other laws pertaining to the exploitation of natural resources, the Court of Appeals used the grandfather rule to determine the nationality of petitioners. Issue: whether the nationality of petitioners are Filipino. Held: no. Basically, there are two acknowledged tests in determining the nationality of a corporation: the control test and the grandfather rule. Paragraph 7 of DOJ Opinion No. 020, Series of 2005, adopting the 1967 SEC rules which implemented the requirement of the Constitution and other laws pertaining to the controlling interests in enterprises engaged in the exploitation of natural resources owned by Filipino citizens, provides. Shares belonging to corporations or partnerships at least 60% of the capital of which is owned by Filipino citizens shall be considered as of Philippine nationality, but if the percentage of Filipino ownership in the corporation or partnership is less than 60%, only the number of shares corresponding to such percentage shall be counted as of Philippine nationality. Thus, if 100,000 shares are registered in the name of a corporation or partnership, at least 60% of the capital stock or capital, respectively, of which belong to Filipino citizens, all of the shares shall be recorded as owned by Filipinos. But if less than 60%, or say, 50% of the capital stock or capital of the corporation or partnership, respectively, belongs to Filipino citizens, only 50,000 shares shall be counted as owned by Filipinos and the other 50,000 shall be recorded as belonging to aliens. The first part of paragraph 7, DOJ Opinion Number 020, stating shares belonging to corporations or partnerships at least 60% of the capital of which is owned by Filipino citizens shall be considered as of Philippine nationality, pertains to the control test or the liberal rule. On the other hand, the second part of the DOJ opinion which provides, if the percentage of the Filipino ownership in the corporation or partnership is less than 60%, only the number of shares corresponding to such percentage shall be counted as Philippine nationality, pertains to the stricter, more stringent grandfather rule. The grandfather rule, petitioners reasoned, has no leg to stand on in the instant case since the definition of a Philippine national under Section 3 of the FIA does not provide for it. They further claim that the grandfather rule has been abandoned and is no longer the applicable rule. They also opined that the last portion of Section 3 of the FIA admits the application of a corporate layering scheme of corporations. Petitioners claim that the clear and unambiguous wordings of the statute preclude the court from construing it and prevent the court's use of discretion in applying the law. They said that the plain, literal meaning of the statute meant the application of the control test is obligatory. We disagree. Corporate layering is admittedly allowed by the FIA, but if it is used to circumvent the Constitution and pertinent laws, then it becomes illegal. Further, the pronouncement of petitioners that the grandfather rule has already been abandoned must be discredited for lack of basis. Article 12, Section 2 of the Constitution provides, all lands of the public domain, waters, minerals, coal, petroleum and other mineral oils, all sources of potential energy, fisheries, forests or timber, wildlife, flora and fauna, and other natural resources are owned by the state. With the exception of agricultural lands, all other natural resources shall not be alienated. The exploration, development, and utilization of natural resources shall be under the full control and supervision of the state. The state may directly undertake such activities, or it may enter into co-production, joint venture or production sharing agreements with Filipino citizens, or corporations or associations at least 60% of whose capital is owned by such citizens. Such agreements may be for a period not exceeding 25 years, renewable for not more than 25 years, and under such terms and conditions as may be provided by law. The emphasized portion of Section 2 which focuses on the state entering into different types of agreements for the exploration, development, and utilization of natural resources with entities who are deemed Filipino due to 60% ownership of capital is pertinent to this case, since the issues are centered on the utilization of our country's natural resources or specifically, mining. Thus, there is a need to ascertain the nationality of petitioners since, as the Constitution so provides, such agreements are only allowed corporations or associations at least 60% of such capital is owned by such citizens. It is apparent that it is the intention of the framers of the Constitution to apply the grandfather rule in cases where corporate layering is present. Elementary in statutory construction is when there is conflict between the Constitution and a statute, the Constitution will prevail. In this instance, specifically pertaining to the provisions under Article 12 of the Constitution on National Economy and Patrimony, Section 3 of the FIO will have no place of application. As decreed by the honorable framers of our Constitution, the grandfather rule prevails and must be applied. Likewise, Paragraph 7, DOJ Opinion Number 020, Series of 2005 provides, the above here quoted SEC rules provide for the manner of calculating the Filipino interest in a corporation for purposes, among others, of determining compliance with nationality requirements, the investee corporation. Such manner of computation is necessary since the shares in the investee corporation may be owned both by individual stockholders, investing individuals, and by corporations and partnerships, investing corporation. The said rules thus provide for the determination of nationality depending on the ownership of the investee corporation and, in certain instances, the investing corporation. Under the above here quoted SEC rules, there are two cases in determining the nationality of the investee corporation. The first case is the A-liberal rule, later coined by the SEC as the control test in its May 30, 1990 opinion, and pertains to the portion in said paragraph 7 of the 1967 SEC rules which states, A shares belonging to corporations or partnerships at least 60% of the capital of which is owned by Filipino citizens shall be considered as of Philippine nationality. Under the liberal control test, there is no need to further trace the ownership of the 60%, or more, Filipino stock holdings of the investing corporation since a corporation which is at least 60% Filipino owned is considered as Filipino. The second case is the strict rule or the grandfather rule proper and pertains to the portion in said paragraph 7 of the 1967 SEC rules which states, but if the percentage of Filipino ownership in the corporation or partnership is less than 60%, only the number of shares corresponding to such percentage shall be counted as of Philippine nationality. Under the strict rule or grandfather rule proper, the combined totals in the investing corporation and the investee corporation must be traced, that is, grandfathered, to determine the total percentage of Filipino ownership. Moreover, the ultimate Filipino ownership of the shares must first be traced to the level of the investing corporation and added to the shares directly owned in the investee corporation. In other words, based on the said SEC rule and DOJ opinion, the grandfather rule or the second part of the SEC rule applies only when the 60-40 Filipino with foreign equity ownership is in doubt, that is, in cases where the joint venture corporation with Filipino and foreign stockholders with less than 60% Filipino stock holdings, or 59%, invests in other joint venture corporation which is either 60-40% Filipino alien or the 59% less Filipino. Stated differently, where the 60-40 Filipino, foreign equity ownership is not in doubt, the grandfather rule will not apply. After a scrutiny of the evidence extant on record, the court finds that this case calls for the application of the grandfather rule since, as ruled by the POA, and affirmed by the OP, doubt prevails and persists in the corporate ownership of petitioners. Also, as found by the CA, doubt is present in the 60-40 Filipino equity ownership of petitioners Narra, McArthur and Tesoro, since their common investor, the 100% Canadian corporation, MBMI, funded them. However, petitioners also claim that there is doubt only when the stock holdings of Filipinos are less than 60%. The assertion of petitioners that doubt only exists when the stock holdings are less than 60% fails to convince this court. DOJ Opinion Number 20, which petitioners quoted in their petition, only made an example of an instance where doubt as to the ownership of the corporation exists. It would be ludicrous to limit the application of the said word only to the instances where the stock holdings of non-Filipino stockholders are more than 40% of the total stock holdings in a corporation. The corporations interested in circumventing our laws would clearly strive to have 60% Filipino ownership at face value. It would be senseless for these applying corporations to state in their respective articles of incorporation that they have less than 60% Filipino stockholders since the applications will be denied instantly. Thus, Various corporate schemes and layerings are utilized to circumvent the application of the Constitution. Obviously, the instant case presents a situation which exhibits a scheme employed by stockholders to circumvent the law, creating a cloud of doubt in the court's mind. To determine, therefore, the actual participation, direct or indirect, of MBMI, the grandfather rule must be used. To establish the actual ownership, interest or participation of MBMI in each of petitioners' corporate structure, they have to be grandfathered. As previously discussed, McArthur acquired its MPSA application from MMC, which acquired its application from SMMI. McArthur has a capital stock of 10 million pesos divided into 10,000 common shares at 1,000 pesos per share. Interestingly, looking at the corporate structure of MMC, we take note that it has a similar structure and composition as McArthur. In fact, it would seem that MBMI is also a major investor and controls. Noticeably, Olympic Mines Development Corporation, Olympic, did not pay any amount with respect to the number of shares they subscribed to in the corporation, which is quite absurd since Olympic is the major stockholder in MMC. MBMI's 2006 annual report sheds light on why Olympic failed to pay any amount with respect to the number of shares it subscribed to. It states that Olympic entered into joint venture agreements with several Philippine companies, wherein it holds directly and indirectly a 60% effective equity interest in the Olympic properties. Thus, as demonstrated in this first corporation, McArthur, when it is grandfathered, company layering was utilized by MBMI to gain control over McArthur. It is apparent that MBMI has more than 60% or more equity interest in McArthur, making the latter a foreign corporation. Tesoro, which acquired its MPSA application from SMMI, has a capital stock of 10 million pesos divided into 10,000 common shares at 1,000 pesos per share. Except for the name Saramari Mining, Incorporated, the table above shows exactly the same figures as the corporate structure of petitioning McArthur, down to the last centavo. All the other shareholders are the same: MBMI, Salazar, Escra, Agca Oyali, Mason and Calcal. The figures under nationality, number of shares, amount subscribed, and amount paid are exactly the same. Concluding from the above his stated facts, it is quite safe to say that petitioners McArthur, Tesoro and Narra are not Filipino since MBMI, a 100% Canadian corporation, owns 60% or more of their equity interests. Such conclusion is derived from grandfathering petitioners' corporate owners, namely, MMI, SMMI and PLMDC. Going further and adding to the picture, MBMI's Summary of Significant Accounting Policies Statement A regarding the joint venture agreements that it entered into with the Olympic and Alpha Groups A involves SMMI, Tesoro, PLMDC and Narra. Noticeably, the ownership of the layered corporations boils down to MBMI, Olympic or corporations under the Alpha Group wherein MBMI has joint venture agreements with, practically exercising majority control over the corporations mentioned. In effect, whether looking at the capital structure or the underlying relationships between and among the corporations, petitioners are not Filipino nationals and must be considered foreign since 60% or more of their capital stocks or equity interests are owned by MBMI,